Thank you for joining us today for the ABA Civil Rights and Social Justice section Chair Chat. My name is Bob Dinerstein. I'm a professor of law emeritus at American University Washington College of Law and co-chair of the Disability Rights Committee of the section. And I'm thrilled to welcome you to this conversation with one of my best friends, Jasmine Harris. These chats are a unique opportunity to engage directly with the key issues at the heart of our work in civil rights and social justice, exploring the perspectives of our experts, and sparking discussions that inspire action in this area. Today's topic, disability rights, is more critical than ever. As we confront the past, present, and future disability rights movement, it is essential to examine how these issues intersect with the principles of justice and equity that guide the work of the ABA. We're honored to have with us today Jasmine Harris, professor of law at University of Pennsylvania, Carey School of Law. Her expertise and dedication have made her a leading scholar and advocate in the disability rights field, and we're grateful for her willingness to share her insights with us. Jasmine taught with me at the Disability Rights Law Clinic of the American University Washington College of Law back in 2012 to 2015, just seems like yesterday. She then went to teach at University of California, Davis School of Law, and then came back east to join the faculty as a tenured faculty member at Penn's Law School in 2021. She's a prolific scholar in disability rights and has emphasized in her work issues of anti or non-discrimination, legal capacity, privacy, aesthetics, among other subjects, and she can elaborate on that if she wishes. She's actively involved also in a number of disability rights organizations like the ARC and Jacobus Ten Broek Symposium and other organizations. And as I said, I'm proud to call her a good friend and a colleague. So without further ado, let's jump in and please join me in welcoming Jasmine Harris to the conversation.
Thanks, Bob. I just want to say I'm pleased to be here and thank you for that generous introduction.
Oh, sure. I got your bio, and if we really did that, it would take probably another half hour. So it's a little bit truncated, but I do encourage you to go to Jasmine's webpage on the Penn website and see all the wonderful things that she's been doing. She really is uh, written some just terrific things and has really taken an important perspective on disability rights that I think hasn't always been seen. So, my thought in this conversation, which is meant to be conversational, so as I've said to Jasmine, when I'm talking, she should feel free to jump in or ask questions, and I will do the same when she is. And our structure for this was to talk about the past of disability rights, the present, and then speculate a little bit about what we think about in the future. And as the oldest member of this group, I took the prerogative of starting at about the past. And this is the 60th anniversary of the section, which is why I think this year we're holding a number of these chats, which meant in 1965 was when the section started. And when you look at the disability rights movement, there really wasn't much of a movement back in 1965. I mean, one of the things that actually happened that year, interestingly enough, many people probably remember, or at least in the disability rights world, remember that in 1972, Geraldo Rivera, then a local reporter for Channel 7 in New York City, WABC, made an unannounced visit to Willowbrook State School, a school in quotes for people with intellectual disability, and had brought in cameras and spoke to people and showed the horrified conditions that existed in that facility, which actually led to a long-running lawsuit about it. Well, that was actually not the first visit to Willowbrook. In fact, the first one, which at least I'm aware, by an outsider, was by Senator Robert Kennedy, not the current Secretary of HHS, but his father, when he was had just been elected to the New York Senate and went in an unannounced visit to Willowbrook in 1965, and described, after going through that tour, described the institution as a snake pit. A term which has been used for many of these kinds of institutions. And so Kennedy, as you may know, his family had a connection to disability. His sister, Rosemary Kennedy, had intellectual disability and maybe a psychosocial disability as well. She actually wound up being, this is a very sad story, her father, without actually her mother's knowledge, had her lobotomized, and then she was institutionalized in a Catholic institution in Wisconsin for the rest of her life. But she was, before all that, was a full-fledged member of the Kennedy clan. She was, described in books as quite delightful, as outgoing. I think there were issues here of concerns about her promiscuity, which is, I think, what led her father in part to have her lobotomized. A very sad story, and also one that is unfortunately common or has been common in the regulation of the sexual and reproductive rights of people with disabilities over time. Going back earlier to the infamous case of Buck v. Bell, which sterilized a young woman supposedly based on her intellectual disability. Parentheses, turns out she really didn't have intellectual disability, nor did her mother, nor did her daughter. But that was in 1927. Supreme Court put its imprimatur on that involuntary sterilization. And then in the Kennedy clan, in addition to Rosemary's being a member of the family, as you may know, Eunice Kennedy Shriver, the sister of the president and Robert Kennedy, started Special Olympics, which continues to be a vibrant organization to this day. And John Kennedy, in 1963, actually issued the first that we know of really mental health oriented presidential message, calling for a bold new approach to providing services to people with, particularly with psychosocial or mental health disabilities, which led to the proposal to create a system of community mental health centers, which was part of a law that was passed in that era as well. Also, the Community Mental Health Centers and Mental Retardation Facilities Act in that year. And eventually, by the way, the Mental Retardation Facilities Act became, through various machinations over the years, the Developmental Disabilities Rights Act, Developmental Disabilities Act, which many folks know about still today. So that's really where a lot of the statutory beginnings of what might be thought of disability rights, but it wasn't really framed in disability rights terms. The other things that were going on in this era in the late 60s was really some activity at the state level, and particularly in the District of Columbia, led by Chief David Bazelon, Chief Judge. Bazelon issued several decisions, one on a right to treatment in a case called Browscourt versus Cameron in 1966, and then in 1969, a case called Covington versus Harris, which talked about the importance of, even when you were institutionalizing somebody, that you do so in the least restrictive manner, an important principle that has had legs throughout the history of the disability rights movement. But at the federal level, I think the first statute really that was passed was the Architectural Barriers Act in 1968. So again, you can, as a early in the history of the civil rights and social justice section, there really wasn't statutory protection for people with disabilities. This 1964 Civil Rights Act, of course, covered race and sex eventually, but not disability, which was at some point proposed as a possibility, but it did not go anywhere. So in that era, it wasn't much in the way of statutory rights. What did happen, though, importantly in the early 70s, early to mid 70s and later, were constitutional challenges to conditions in facilities for people with intellectual disability, then called mental retardation, and psychosocial disabilities. And some of the lead cases in that era were the Wyatt case in Alabama, which concerned both facilities for both kinds of folks, and over time covered statewide facilities. Willowbrook, as I mentioned earlier, which was in New York. Pennhurst in the Philadelphia area, which led to one of the most far-reaching lower court decisions in this era. I was, at the time, worked in the Civil Rights Division of Justice in the late 70s and was heavily involved in the Wyatt case, which at that point was in compliance stages. So one thing I want to kind of say to folks as they watch this is many of the lead and kind of landmark cases in the disability rights area have taken years and years to go from filing of complaint to ultimately conclusion of the case. Wyatt was filed in 1970. It was actually filed on behalf of employees at the facility at the Bryce Hospital who were going to be laid off. And the story goes that the complaint was filed and the lawyers met in chambers with Judge Frank Johnson, who was a hero of the civil rights movement for his enforcement of rights of African Americans in Alabama in a variety of cases. And Johnson said, Well, I'm not that interested in this case with regard to employees, but I am interested in the kind of treatment that people are getting there. So he kind of hinted, more than hinted, that right, that if people were going to be locked up or housed in large institutions, at a minimum, they needed to get treatment. Otherwise, it was warehousing them. And of course, at that point in that late 60s, early 70s, really, that's what was going on in a lot of these institutions. I think the height of institutionalization for people with mental health disabilities was in 1954. About 500,000 people were institutionalized at that point. For people with intellectual disabilities, a little later, 1967, but still a huge number of people, if they weren't at home with families, they were in institutions. There were no real community-based programs to speak of at that point. And Johnson presided over this case. It wound up with several opinions. He invited, quote unquote, the government, federal government, to come into the case. And the Justice Department, under Richard Nixon, as it turned out, accepted that invitation and filed and became what was called a litigating amicus curiae. That is a friend of the court, but not just filing a brief in support of the parties, but actually with all the rights of a party except the right to appeal. And so, in any event, combination of private plaintiffs, Justice Department, the then called Mental Health Law Project, later the Bazelon Center for Mental Health Law, prevailed in a couple of landmark decisions in 1972. But enforcement of that case, my involvement was in the 1978 to 82 period. It actually went all the way up through the early 2000s because as these cases went forward, the orders, which were extensive, part of a law reform process, meant that in addition to simply making sure that people were getting adequate treatment, following them into community-based programs, making sure that they were not just dumped on the streets, but were provided with support, and just the difficulties of providing the right kind of staff and right kind of support for people just took a long time to get right. And so whether it was Wyatt or Willowbrook or Penhurst, these cases or Forest Haven in the DC area, just took a long time. I will say that I still have, maybe I would call them either bad dreams or nightmares of some of the tours of those facilities in that era. And while the worst of those cases are uncommon today in the US, they're not zero. And if you look internationally, they still exist. In fact, yesterday I was on a panel, a student group at George Washington University was putting on a project, and we did a discussion about conditions in a facility in Guatemala, which is the subject of proceedings before the Inter-American Commission on Human Rights in the Latin American area, which is also going to go up to the Inter-American Court of Human Rights and the Federico Mora Institution. And again, the pictures of people in there, the being conditions under which they're kept, their beds, their strip beds with nothing on them, lack of activity, being apparently sexually trafficked, just lots of things that happened to some degree in U.S. institutions, as I said, 70s, 80s, into the 90s even. That has really kind of was an important part of what disability rights was at that time. And so, first of all, there was a movement in those cases from getting institutional conditions better because they were so bad, which in some of the early cases was the emphasis, to a recognition, and I think Penhurst really was the case that pushed this in 1977 and 78, that no institution would be appropriate for almost all, if not all, of the people in that institution. So the places we're talking about, Willowbrook is closed, Penhurst is closed, Forest Haven is closed. Many of these institutions are either much, much smaller or closed altogether. And that's because of a recognition, which I don't think was there at the beginning, that in fact, the people, even if you made everything wonderful and had great staffing and people were not being abused, it's not the way any of us would want to live. Institutional life is not the kind of life that most of us aspire to. And even when we live in institutions like college dorms or military barracks, they're short term. They're not for people's lives, which is what in fact had happened in those early cases. So they were for me, certainly very powerful in terms of my understanding of disability rights. And certainly I was not alone in that area, but that was all being done really without statutory authority. It was really the private plaintiffs brought constitutional cases. The Justice Department intervened, often being challenged for its authority until the passage of the Civil Rights of Institutionalized Persons Act in 1980, the CRIPA, so-called CRIPA. Um, and at the same time, and I will say that in addition to this focus on institutionalization of people with disabilities more generally, there had been an earlier movement. In fact, it kind of preceded it in some ways to push for a right to education, particularly for children with emotional disturbance or so-called or with intellectual disability. And two of the major cases in that era were district court cases. Pennsylvania Association for Retarded Citizens versus Commonwealth of Pennsylvania, and Mills versus District of Columbia. These were early 1970s era cases that essentially took an argument about the equal protection and the need for education to be presented equally based on race out of Brown and applied it to the disability area. Those two cases became critical to the passage of what in 75 was called the Education for All Handicapped Children Act, and later renamed the Individuals with Disabilities Education Act, which we still have today. So that again, that statute has evolved over time, and in many respects, it's never been fully funded or fully supported, but it does establish some important principles, which again, many people in disability rights area know about. The individualized education program that defines the services that people need, among other things, and the right to have a free, appropriate public education, which is a critical right for people in the K through 12 time frame. So those were a lot of the cases that with a lot of those developments. Again, a lot of it was institution focused and then getting people out of and keeping them out of institutions. So that was an important part. Educating them in the community with kids without disabilities. That was one of the key elements of again, the Education for All Handicapped Children Act at that time. To not, in DC, for example, kids with emotional disturbance were getting no education. And when kids were even getting education in special ed, they was separate and not at all integrated. So that was the move to try to put them into as much as possible into traditional regular classrooms with support, or if not, and if not in a regular classroom in the school, at least in a classroom in the school, and then moving to less restrictive or more restrictive options, but not reaching those unless one had to. I'm going to shut up at this point in terms of past work, and I don't know if you have anything to add about that, Jasmine, until we kind of move it up a little bit.
I do. So that was incredibly comprehensive. So I just had a couple of thoughts that I wanted to add. The first is it's a reaction as I listen to you talk about institutionalization and the sort of theory of the state's relationship with people with disabilities and how that's evolved over time. And I wanted to note, and this is something that always strikes me as really a key part of the understanding disability rights and their emergence, is thinking about the Wyatt case in particular, and the move from, as you said, seeing things as people with disabilities actually benefit from institutionalization. They absolutely should be in that environment, and therefore we have to bring cases to make it the best possible conditions under which they will live in that setting, or maybe not the best possible conditions, but certainly make them minimally adequate, to use the language from Youngberg versus Romeo. And how you get to Wyatt, and the expert in Wyatt goes into these institutional settings and says, you know, look at the people in the main unit. And you see this in Willowbrook, and you see this in Geraldo Rivera's expose as well. People are banging with disabilities are banging their heads against the wall. They're in these, they're exhibiting these behaviors that are not normative. They seem unusual. And, the expert says, this is because they are not being stimulated. They are being warehoused. They are being mistreated. This behavior is a manifestation of their human rights violations, right? So essentially, our very theory, or at least the state's theory of interacting with people with disabilities, was based on a notion that these behaviors somehow required differential treatment, when the behaviors were simply the product of how the institutions were being designed and run. And so we then have a move from that to a move away from institutions and seeing it as well, institutions may not be the best way to go. Community-based care is not only cheaper, but it is something that might be more meaningful and allow for full inclusion in society. So that always, that was one piece of it. And hearing you talk about the Guatemala case made me think about that image, I guess, most directly of people being warehoused in those ways, and kind of that shift between or from custodialism and institutionalization to community-based care, and how state laws, federal law and policy are shifted at that point away from that. The other thing is to say, as I listen to you talk about the statutory history, to just bring up Cleburne and just to say that, part of what was happening, and as you said, constitutional law played a role in thinking about the conditions of confinement and the restriction of liberty interests. But when we get to Cleburne versus Cleburne Living Centers, and I'm of course blanking on the year right now at the moment, it's
1985. Yeah.
85. That's it.
Right.
I was going to say 83, but I had something else for 83 in my head. In 85, by the time we get to 1985, the Supreme Court has to think about disability as a class. Is it a protected class of individuals, people with intellectual disabilities, just to be really precise? And the court says, actually, for all of these different reasons, the state has a legitimate interest in regulating and the decisions and decision making with respect to people with disabilities. They are with intellectual disabilities. There is a cognizable difference between people without intellectual disabilities. And then you kind of get the rational basis review, right? And that's the emergent, whether it's with teeth or not, and scholars have debated whether it was or wasn't. That's the moment when you see the kind of constitutional law framework moving into the background in terms of thinking about disability rights and remedies. So just those two notes, and very quickly, I had three notes. So the third note, the third note was just to say that there was another interesting moment in thinking about why do we have the disability rights framework that we currently do. And I think back to the conversations in letter form, no emails, no text, nothing like that, between Jacobus Tenbroek and Thurgood Marshall, as Thurgood Marshall was thinking about litigating Brown versus the Board of Education, and Jacobus Tenbroek, who was a political science professor, as you know, Bob, at the University of California, Berkeley, and later went on to found and then lead the National Federation of the Blind. He was a constitutional law scholar who was thinking about the anti-slavery origins of the 14th Amendment. I think that book was out in 1951. So the kind of cross-pollination between racial justice and disability rights, and what would become later what we have now is sort of thinking about disability justice, that was happening and brewing. And I think that's an important part of the framework as well.
Yeah, absolutely. And just bouncing off a couple of your points, and we'll move on to something like the president. Although I define president as 1990 until, just
Yeah.
for some of you may seem as still being passed. Um, that in the institutions, they were so focused on a kind of defect version of the people there that when somebody, for example, demonstrated what would be called maladaptive behavior, rocking a lot or hitting themselves or doing, instead of thinking, well, maybe that's because they're understimulated in an appropriate way,
Hmm. Hmm.
we need to restrict it. So you had people who were in physical restraints. You had people who were sent to seclusion rooms, a locked room by themselves. You had people who they had something they called overcorrection. So if you spilled something on the floor, the behaviorist said, well, what you need to do is get a mop and not just mop it up, but like mop it up multiple times to kind of, build into you that this was bad behavior that you needed to overcome. And at some point, our experts, again, thinking in like this late 70s era, said, a better way to do this would be to actually substitute appropriate kind of education and training. And that will, in
Right,
fact,
right.
serve to suppress this other behavior, because that other behavior is not inherent to somebody who had intellectual disability. It's something that was their response to an environment that was so lacking. So
Absolutely.
it was really interesting in that, and I think the effort to say, well, institutions maybe not right for people with mild or moderate level of disability, but certainly are needed for people whose disability is severe or profound. And of course, in the end, that turned out not to be the case either. The other thing I wanted to mention, I think it is true that Cleburne, even though it had a period of time where people argued it seems like a more powerful type of review than that's typical rational basis review, as you mentioned, so-called rational basis with Bite, which later got sort of shot down. Youngberg, even as it recognized some level of constitutional protection for people in institutions, also pretty much sent a clear message that the broader view of a right to treatment or a right to habilitation and a least restrictive alternative was not where the court was going to go. It wound up accepting a much more minimal right to training consistent with having people not be have their bodily integrity interfered with or abused. And one of the things I had used in some of my writing is the exchange at oral argument between I think it was Justice Powell. That in that era they didn't identify who the justice was, but it's pretty clear it was from Powell, asking the lawyer for Youngberg for Romeo, excuse me. By the way, this was about the Penners facility. Well, are you seeking to basically challenge his initial commitment to the facility? And the lawyer said that he wasn't, but that got interpreted not as just, well, we're not challenging the original commitment, we're challenging the continued confinement, which is what his position was. Somehow the court interpreted that as that Romeo was not arguing that he should be placed in the community, that essentially he had an IQ, as they memorably described it, as between 8 and 10. And of course, he would always have to be institutionalized. Well, about 2 or 3 years later, after the court decision, Nicholas Romeo was placed in a community-based program. Penner's was closed. So that assumption was wrong, but it also just meant that, as I look back, it really was pretty much the death knell for a long time of constitutional oriented attacks. And one of the reasons also is, we'll get to this in the next segment, there was then more vibrant statutory support through Section 504 and ADA. But it wasn't just that. It was also that the combination of rational basis review and this kind of minimal understanding, which I think the court never really understood, meant that they weren't going to go as far as advocates wished them to go. So that's kind of up through, 65 through 1990. And Jasmine, I'm going to turn to you for 1990 on for the next segment.
Great. Thanks, Bob. I was thinking about this, and maybe I'll even go back just slightly, just
Mhm.
thinking about the ways in which the ways in which the ADA was made possible because of, at least at the time, this bipartisan view of disability where you can have in one room, Bob Dole and Tom Harkin going across the aisle and working together with other folks, including just important as I was thinking about the passage of the ADA, I was thinking about the role of Major Owens from New York, Representative Major Owens, who was an African American representative in Congress, and he began his career in 1983. And so I like to think about this as, here's a really junior congressman who comes in and is like key on thinking about the ADA and thinking about disability, and as someone who comes from the uh,
Mm.
uh, a racial justice background as well, in terms of some of the earlier work that he had done even before going to Congress. And so you see, and we'll talk about this, maybe Bob and I, we keep doing this as talking one piece ahead in terms of the future, but the way in which disability and racial justice have always kind of been a part of one another, and not always visibly, I think is important as part of what we're doing here. And I love that we're having this conversation when we can elevate the work of folks who were doing this back then. But as you said, Bob, when we get to the ADA, of course, being the most comprehensive legislation, federal statute with respect to the rights of people with disabilities in the United States, and it was preceded by Section 504 of the Rehabilitation Act in 1973. As part of what you were saying, this kind of the 1970s was a time of transformation in so many ways, socially, politically, with respect to disability rights, the height of the legal changes that were happening in this arena. And so 504, of course, it applied to programs receiving federal funding, and so its limitation was that federal spending hook, and so it wasn't as comprehensive, although it reached fairly far. It didn't reach private parties in a number of places, was incomplete in the employment arena and in the public accommodation space, and so the Americans with Disabilities Act, its top three, its top three titles, one, two, three in order, really address some of those gaps in coverage in terms of providing a safety net and a remedy for disability discrimination in employment, in public programs and services under Title II, and then in places of public accommodations under Title III. And of course, as I tell my students all the time, there's more than Titles I, II, and III in the Americans with Disabilities Act. But for our purposes and limited time, I'm going to mention those three. But of course, the other titles deal with transportation and other accessibility issues. Uh,
And I'll just jump in here for a second and
sure, sure,
say
sure,
that
absolutely.
one way which I've written about, and I think it makes sense, is the structure of the ADA, the titles that you mentioned, have analogs in the 1964 Civil Rights Act.
Right.
So whereas the 64 Rights Act, Title VII deals with employment, Title I of the ADA does. Title III of the ADA, which deals with public accommodations, has its analog in the 64 Act. And so the structure of it looks like the 64 Act. The content looks to Section 504 and the regulations under that. It's kind of an interesting combination of influences in that way.
I also think, though, structurally, starting with employment was key, right? That was one of the precipitating factors that was really leading this effort, this bipartisan effort to increase the employability of people with disabilities, and really very much at a time in 1990 when you saw their civil rights, I want to say other civil rights protections at least being challenged and narrowing in terms of standing and other issues. You saw the ADA come to the fore, partly on the basis of this is an anti-welfare kind of statute where it's here are individuals with disabilities, many capable of being in the private workforce, and we ought to be encouraging that. And so I agree with you 100%. I think that the structure of the ADA tells a story as much as the content as we go piece by piece.
Yeah.
And I think, we even starting before Title One is an important place to start. And I think understanding that the ADA itself is something that was that is different from other civil rights statutes in that you have a threshold definition of disability where Congress put this in place to decide who is entitled to the statutory protections contained within. So unlike, let's say, the Civil Rights Act and Title VII, if I'm making a claim of employment discrimination, for example, on the basis of race or national origin, I wouldn't have to prove that I am a person of color from X country. I can make the claim and I don't have to prove it as an element of the claim. Where here you do. And so Congress put in place a definition that was a threshold definition and actually became the core part of the doctrinal landscape for 18 years. And most of the early life of the ADA was spent fighting in court about whether someone was in or out, whether they met the statutory definition of disability, whether Congress meant for, someone to be covered under the ADA who could mitigate their disability. And as you know, the Sutton trilogy went up before the U.S. Supreme Court in 1999, and the lead case Sutton versus U.S. Air United Airlines, sorry, I said U.S. Air. United Airlines was about the Sutton sisters, and the Sutton sisters themselves had acute visual myopia, and the issue there really had to do with whether Congress intended the definition of disability to include people before they had a mitigating measure applied or after they had a mitigating measure applied. And the difference was significant. It wasn't a difference without a distinction. And that was really what led to the trilogy of cases where the US Supreme Court ultimately said, Congress couldn't possibly have meant this to be broad statutory coverage for people. In the legislative history, it said that there were 43 million people with disabilities in the United States. And if you included people who could mitigate their disability with medication, with glasses, with other measures like that, then the 43 million would double or triple. And that's basically the reasoning in that trilogy of cases. And so you had the US Supreme Court saying this is a statute that is narrowly defined, right? And giving that direction moving forward. And I love this story, Bob, in terms of kind of geeking out on the the way in which the branches talk to each other. And so the US Supreme Court, you have the Sutton trilogy comes down, lower courts then say, okay, they then proceed to narrowly defined disability. Motions to dismiss are increasing. You have, all of these sort of dispositive motions on this question, this threshold question, never getting, or I don't want to say never, but rarely getting to the substantive claim of discrimination under the ADA. And then you have Congress in 2008 saying, you got it wrong. You got it wrong, Supreme Court. We meant this to be broad coverage, a broad definition of disability, not one that was going to be a high threshold and bar. And then the story, for many people, the story ended there, right? It was like, okay, now the agencies took this up and they have regulations, EEOC, DOJ, that this should be interpreted broadly, shouldn't be a high bar. But the story's not over, right? And one of the things I wanted to mention in this present is how incredibly relevant. When I used to teach, when I first started teaching disability law, I almost skipped over. I spent very little time, admittedly, on the definition of disability because we had these robust regulations and it was or understood more or less this is solved. Well, the debate of whether someone is disabled or not as a statutory matter continues. We saw it kick up in COVID and with long COVID. And we've seen it most recently come out in the context of trans identity and in terms of gender dysphoria in the Williams versus Kincaid case. And so these are very live issues. Why? Because one, our understanding of disability is constantly in motion and organic as a research matter, but also in terms of the number of people who are moving in and out of this classification is making us kind of think about this in a different way. And so the major issue there, of course, is adding to that the political nature of it. And I mentioned Williams versus Kincaid. And of course, I'd be remiss if I didn't say how this is a very live issue at this moment as to whether gender dysphoria uh, precludes someone from being covered under the ADA because there was an exclusion in the original statute for gender identity disorder. And so the question of whether that is a bar to protection under the ADA, Williams versus Kincaid, that was the first time that it was actually an issue of first impression. And then under the Biden administration, HHS, when it revised its 504 regulations, said in the regulations, actually, this is per Williams versus Kincaid, this is not a bar to receiving protection under the ADA. And most recently, well, actually, before we go most recently, then you had in 2004 or 2024, you had Texas versus Becerra that was filed and basically by governors of I forget how many states, but a number of there were all red states and governors who filed this action challenging the legitimacy of the regulations themselves and putting
And I
into
think they've also it said that the administration has announced they haven't yet taken apart all the changes to the
right.
504 regulations, but they have said that they will not enforce the um, preamble, which is where the
which is where it
regulations
was.
talked about gender dysphoria. The other
Exactly.
interesting thing about that, or there are many interesting things, but not every trans person would necessarily be experiencing gender dysphoria. And I
Correct.
think for
Correct.
some people, using disability as a basis of civil rights protection is not uncomplicated for them because their identity is not one of disability, it may be one of difference. That also applies to other people with disabilities. There are many people in the deaf culture, say capital D deaf, who think of their hearing impairment as a difference, not as a disability, which is complicated if you then want to use the statutes which do talk about them as impairment and as difference to get services. And so I think there's been some discussion about that over time. But it is interesting because that identity of having a
Hmm.
disability, which I think in a rights-based approach seems like, of course, embrace that. Because of societal reaction to disability, because of stigma, is often resisted, even when it
Hmm.
might be helpful. In fact, there was a recent article in the New York Times about how a number of older persons who are absolutely experiencing, sensory disabilities and otherwise, do not claim that title. They don't want to be considered disabled. They have, let's say, internalized the views of of those who think that people with disabilities are less than and not just different from. So it makes it a kind of interesting, way of thinking
Complicated.
about it. It's also interesting, as an aside, because you rightly point out the problem with the Supreme Court interpretations making that threshold question of do you have a disability so important that the Congress said you basically are missing the forest for the trees. The one advantage of it, which I haven't seen people say so much about, but I think is true, is you don't have the phenomenon of the reverse discrimination cases
Right.
that you have in the 64 Act, where a white person can say, I'm discriminated on the basis of race. A person without a disability does not have a standing, with minor exceptions, to be able to sue under the ADA. So much as I certainly see all the problems, as you identified with that standard of that threshold standard. The one way in which it's been, say, protective is it doesn't give the so-called able-bodied person the opportunity to use that statute. The other thing I would just say is, and maybe we'll get into this in talking a little bit about the future or late present current future, is many people in the disability rights world and disability justice world, of course, talk about the models of disability that operate at the societal level, not necessarily at the legal level. And that the model of choice, I think, for many is the so-called social model of disability, which looks less at the impairment that the person may have, but rather sees disability as a product of the interaction between the individual and his or her environment, including both built environment and attitudinal environment.
Hmm.
And I think there's many ways to view the ADA as a social model statute. However, the definition of disability, which is very medicalized, means that it kind of sends mixed messages when it comes to that. And part of the problem that, again, people have faced is, how do I prove that this condition is sufficiently serious in my case to demonstrate that I'm substantially limited in a major life activity, which is the magic language. And you
Hmm.
typically have to go to a healthcare professional of some kind to be able to say that, which means that you are in somewhat of that medical model world, even as you're making an argument that disability is really a social construct.
Absolutely. So I think because of that, I wanted to make sure that we talked about the disability definition and why it's still alive and kicking and it's organic and it's an important part of any discussion about disability rights. I think the other issue when we talk about the present has to be the Eighth Amendment issues that have come up. And so thinking back to Atkins versus Virginia in 2002, where the Supreme Court held that the death penalty, imposing the death penalty on people with disabilities is cruel and unusual under the Eighth Amendment. That then created the standard, but then after 2002, states have had, more than 2 decades to kind of wrestle with, well, then who's in that box? Who constitutes a person with an intellectual disability such that this would constitute cruel and unusual under Atkins? And so states have gone, these are the cases that go up to the Supreme Court, frankly. So we do have Supreme Court doctrine in this area. And in fact, next week, on December 10th, we will have another case in Ham versus Smith, where the Supreme Court will specifically hear argument on the question of how to manage multiple IQ scores and tests in terms of, do you average them together? How do you weigh and balance if they're out of sync? And how should courts look at that vis-a-vis the Eighth Amendment and Atkins? And so, as I was saying, you've Atkins versus Virginia, and states said, well, how do we figure this out? IQ tests became the predominant measure of whether someone, 70 became the cutoff essentially for whether someone had an intellectual disability such that subjecting them to the death penalty would constitute cruel and unusual. But as any measure, you talk about medical model or not, this is one that's heavily based on experts thinking about whether someone is 70 or within the standard error of measurement, that band between, below 70 and a little bit above 70. And so these questions are quite important with respect to also the future of the death penalty, but particularly given the the uh, the identity of people with disabilities among the population of those who are on death row. It's significant relative to non-disabled people and incarcerated individuals in general. And so, these are really important cases that are before the court. And they're the ones that, again, the court is hearing. This jurisprudence is well developed at the Supreme Court level. So I do think it's a stay tuned, and we have to stay tuned to see. So that's another issue. I guess there's so many issues we could talk about, but I would love for us to transition to legal capacity. Because when you talk about what are the key issues for disability rights today, legal capacity for me and for you more so than me, as I think the one of the key issues on the table. Um, and actually, we just had that conversation recently, so I'm excited to have it again. But what I will say is, when you talk about legal capacity, it's when the law is regulating the decision-making ability and functional capacity of individuals and when it doesn't. And so, when the law cares about it in marriage and voting, or in my own work, thinking about intimate sexual decision-making and those types of choices. And here the issues are really, what criteria do courts use, and what kinds of standards and baselines do they demand of people with disabilities relative to non-disabled people? And so, the issue is, I think, compounded by the fact that many people without disabilities are not in contact with the state and state service providers as often as people with disabilities. So they are subjected to questions of their capacity much more often and surveilled much more often than people without disabilities. So these questions are front and center, and I think they're intertwined with questions of privacy as well, and how much privacy people with disabilities have in their lives and are given.
The
But I
phrase
guess,
I use, the phrase I use for many people with disabilities is most of them live highly mediated lives, and where that mediation
it's
is
great.
frequently with
Yeah, it's a great
government
phrase.
funding, services, regulation, and that it's just hard to just be without people kind of being in your business, so to speak. And even people who I know who are self-advocates who've lived pretty independent lives have said to me, for example, well, there's a staff person that comes over and they look at my stuff in my house, and I kind of resent that. I don't really want that. Some people may need it, but others do not. And we don't always center the person with a disability in trying to figure out what do they really want. We may make assumptions about it based on their diagnosis, based on their level of disability, based on what a family member says they need, but
Hmm.
don't then focus on what they say they want. And my experience, both personal and professional, is most people kind of know what they want. They may need some guidance, some support, which we may get into, but shouldn't be ignored because all these things are about them ultimately.
Right. And I think the tension then becomes, you have these lives that are very much being watched and multiple contacts with state actors. And you have that on the one hand, and then on the other hand, you have, so this is a lack of privacy for people with disabilities. But then on the other hand, you have this legal framework around privacy and disability that doesn't allow for the monitoring and the transparency and the accountability of that reality of the greater context with state actors, where we have laws like HIPAA or FERPA and other privacy frameworks, including within the ADA, that surround information about disability and people, for sometimes because it's a complex system and sometimes because it's just kind of really difficult to understand, is to say, gosh, that's about disability. We can't possibly talk about it. And so, where you would have the sort of kind of protection aspect gets lost because you can't actually see what's happening in those spaces where there are greater state contacts. And so I think that's one of the big points of tension in this area. Certainly one that I've been thinking about for a while, but I think, and you've seen this in the guardianship and conservatorship context. And I would love for us to talk a little bit. I know we could talk for hours about this, but to really get a sense from you and from your expertise on, what are the issues and the guardianship, conservatorship context, supported decision making, and then how does this look in the international arena as well?
Yeah, and I will get to that. One thing before we do, I just want to at least as a mention, and this could be a whole topic of its own, is a really critical Supreme Court case in the late 90s, interestingly decided the same day as the infamous Sutton trilogy, was the Olmstead case, as probably
Mm-hmm.
many people, even who are not disability rights advocates, have heard of. And although ostensibly about the case just about two women who had both intellectual disability and some kind of psychosocial related disability, the Supreme Court, Justice Ginsburg's opinion, said that institutionalization itself was a form of discrimination under Title II of the ADA. And consequently, if people were, wished to be out in the community, were the professionals thought they could survive and thrive in the community, and there was a basic community-based system in place that they needed to be placed there. And that decision, um, robustly enforced in some administrations, less so in others. You can guess which ones. Um, has led to huge amounts of change across many, in combination with some aspects of the Medicaid, home and community-based services funding, has really been the driving force that's led to reduction of and closing of many institutions and making them much lower. So we could do a whole thing on Olmstead. It continues to be a really important case. But to get to your question about guardianship and conservatorship, and you've written wonderfully about this also historically with regard to how it was used with Native Americans and with African Americans as a way of social control. And so, although many people may think of guardianship as kind of, protects people who are vulnerable, that's a good thing. Like lots of things, it's been overused in many respects and provided more protection, let's say, and more overcoming than was needed. And in a lot of ways, I really see guardianship as the community-based equivalent of institutionalization, which is to say that even when there's no issue about a guardian abusing the person under guardianship, either economically or physically, both of which there's ample support for, even when it's functioning well, it's a problem. And the problem is that it takes away decision-making authority from the individual and gives it to someone else. And it's the assumption then is somebody can't be counted on to make wise and rational decisions about where they're going to live, what kind of health care they want, what kind of financial arrangements they want to make, et cetera. And so they need somebody to make those decisions for them. And even though many guardianship statutes and conservatorship statutes say that the guardian or conservator should look to what the person wants as their guiding force in what to decide. Many people, this is anecdotal, but I think pretty safe in saying it, would in fact view their decision making in more of a best interest model. What do they think is best for the person? And as we know, people differ about that, within families, outside of families, otherwise. And so, Claude Pepper, the former representative and then senator, or I guess in the opposite order, described guardianship as a form of civil death
Mm-hmm.
because it takes away the very elements of personhood that we come to expect for other people. And later also said that a felon had more rights than somebody under guardianship. And so creating this kind of structure where someone else takes control of your person and your property and is able to transact on it, whether you know or not, or as we've seen in some international contexts, and maybe even still here, a guardian who makes a decision to commit the person that they're guardian for to an institution and then is leaves because they don't want to have anything to do with them. And the person can't leave because the guardian supposedly is in control of that. And that was certainly something we saw many years ago in countries like Hungary and otherwise. And you know,
Or sorry, Bob, or reproductive rights get stripped away, right? So that's the
right,
other piece of it, which dates
right,
back to Buck versus Bell and Carey Buck in
right.
terms
And,
of,
you know, forgetting that, again, whether you have an intellectual disability or not, there are many people who, like other people, have interests in engaging in intimate behavior and know a lot about that. Maybe need some guidance in some areas, maybe not. But shouldn't be treated as well. When you look at intellectual disability, I think historically there's been two tropes. One is hypersexual, when it's particularly if it's males and a concern that they are sexually predatory, or asexual, that they have no agency in their sexual rights, and consequently any sexual activity they have must be improper and without consent because they can't do that. And again, that does not describe the life experience of many people that I know, that you know, that in fact do understand enough about, intimate behavior, want to engage in it,
mhm,
are open to being educated about those things they need to be. And one of the things about thinking about capacity that I always, emphasize, and I think I did the other day in your class, was that when we compare what level of understanding a person needs for us to be comfortable with them as decision makers, we have to be careful not to establish some kind of ideal level of decision making that we think is out there. So if, for example, a person with intellectual disability there's an issue about whether they should be allowed to vote. Well, we can't establish a system that says, well, you can only be allowed to vote if you can identify who the major parties are, who their candidates are, what they stand for, because so many people vote without disabilities, without any of those considerations, maybe because their spouse votes a particular way, or their parent did, or they misunderstand even who the candidate, they think the name wrong of the candidate, or any number of those
mhm,
things. So while I don't want to dismiss the fact that there's certain basic things you need to understand about any activity in order to make a meaningful decision, it's not perfection that we should be looking for. That said, there are certainly people we know out there who on their own, if they were had to make a decision without in isolation, would probably not understand enough about the decision at stake in order for us to be comfortable with their choice. And for those people, rather than going to a substitution model, a guardian or a conservator to argue to stand in for them, we've developed what's called a supported model, a supported decision making. And you alluded to the international side of this. A lot of this comes out of it's been established in certain countries, but it really got a huge boost with the passage of the Convention on the Rights of Persons with Disabilities, the CRPD, in 2006, ratified by almost every country in the world except the US. The US has signed it under the Obama administration. However, two efforts to ratify it did not get enough votes. It's not coming up anytime soon, although it's actually still on the table in the sense that once you sign a treaty, you have made a commitment to seek ratification. So maybe sometime in the future that will happen. In any event, Article 12 of the CRPD is equal opportunity before the law and says that everybody, no matter what their level of disability, has legal capacity. And the discussions about, well, what does that mean? Is it like psychological capacity? What it really means is you must have the ability to have access to courts and the legal system and everything else. So that my example of the guardian who commits you to an institution and then disappears, that you should still have the ability to challenge that commitment, even if you're under guardianship. If you have a guardian, you still may be able to vote if you could demonstrate, again, you have some basic understanding. You still should have the ability to engage in intimate behavior as you wish, even though you're under guardianship. And that, those things are very important because you have no chance of educating somebody, persuading them, advocating, unless you have a seat at the table. And that seat at the table is what you get if you have legal capacity. And if you need help in exercising that capacity, that's where support comes in. And if you think about it, and we've talked about this, many times, all of us, whether we have a disability or not, frequently have people in our lives who help us make decisions. If if we have a major decision coming up, we may call a friend, we may, speak to a family member, who knows. The key is we get to decide whether to accept that information, that advice or not. We also get to decide who to choose to talk to, right? So if you wanted to operate in a particular way and you know that mom was not so crazy about it, but dad was okay, maybe you go to dad and dad says, yes, son, that's fine. That's
That
something
hits
which
close
all
to
of,
home.
right, right. That would be fine. And we would say there's nothing crazy about it. There's nothing wrong about it. And that should be true for people with disabilities. And again, circumstances indicate you have to be aware if you're the supporter or the group of supporters to not be overbearing, not to, be coercive or to exercise undue influence, but to engage in sort of thoughtful, respectful conversation with people to just find out what they want and, talk to them and
Hmm.
engage with them. And it's one of the things I think a lot about with regard to disability is that, and you alluded to it earlier, Jasmine, which is people who don't have themselves have disabilities or family or other personal or professional connections to it often see it as such an other category. They're not necessarily hostile to it, but they're afraid of it, and they don't even know how to interact with people. Like the
Hmm.
the person in the store who comes in with an assistant, and the cashier only speaks to the assistant and not to the person with a disability. This actually even came up last night in a discussion with, about the Guatemala situation with an advocate who's has low vision and sometimes has somebody with her and, reported how well people talk to, my staff, they don't talk to me. And that's disrespectful of somebody. And yet that stuff kind of happens. So the category of disability, as I said, there's people who resist, even have the disability, resist it because of the stigma. And people who don't have it sometimes, again, maybe it might call it even an etiquette barrier. They're not even really sure how to approach it. And indeed, the ADA itself, in a sense, recognizes that by saying, like, you can't just ask, "Hey, do you have a disability?" And like that question, because we know that by knowing, if you were to answer that question, it might facilitate a kind of discriminatory response. And so, rather than that, you should be focusing functionally, like is somebody, able to perform the essential functions of the job with or without reasonable accommodation, which is again the kind of standard term.
And I think
Um,
that that was the radical move. And radical, I don't mean that in a political sense. I mean in terms of the thinking of it conceptually, of being able to say, look, capacity is not an on-off switch. Functional capacity and therefore legal capacity shouldn't be an on-off switch, that it's not this person does have it or not. Instead, we need to ask the question, capacity for what, and disaggregate according to whatever the thing is: capacity to vote, as you said, capacity to marry. And so to really take this disaggregated view that is more consistent with the way non-disabled people are treated as a legal matter in society.
Right. So, mindful of our time, and although there's so much more to say about what the current state of things is, I want to move us to some level of discussion about the future, and we could be, near future, longer future,
Absolutely.
et cetera. So, I may start it off. One of the things that I think, first of all, I think we will see continuing reduction in the use of institutions. Some of that's for financial reasons, but the move or the keeping people in the community faces a number of obstacles. There are just not enough community-based services available for people. There's not enough well-trained and well-paid staff to support them. And one of the very important sources for funding for folks is the Medicaid program. And again, as people know, Medicaid
Mhm.
program has been subjected to huge cuts in the so-called Big and Beautiful Bill. And even though those cuts weren't necessarily directed at home and community-based services, the practical effect of it may be to limit those because in home and community-based services are not a required part of the Medicaid plan. They're an
Right.
optional part. So if you're a state facing cuts in Medicaid that you have to put through, and you have to choose between cutting a mandatory service or one that is optional, the rational choice probably or might be to go with the optional one. So I have a very big concern about that. I think, even the discussion about, requiring a work requirement for Medicaid it just
Right.
misunderstands, I think, so much of what Medicaid does. But I think if you got rid of Medicaid, all the developments, the positive developments that we've been talking about with regard to the community would disappear because the states simply do not have the funding to support that, and there's certainly not sufficient amount of private funding for that. So that's
Well,
one thing
and
I
just
wanted to mention
for
in
sure,
terms of that.
and to underscore, sorry, Bob, I didn't mean to talk over you. I think I had a lag in my phone. The other thing with respect to the work requirements that you mentioned is there may be an exemption for people with disabilities. And so I just want to be clear that that doesn't mean there's not going to be an impact, because the way that it's written is such that it's going to require people to apply for the exemption, which creates administrative tasks and administrative burdens, which may not be able to be met depending on the supports the person has or not, could result in a loss of services because they don't submit something on time. And so this
Right.
could be really significant.
Right.
So
Which
just
some have said,
underscoring this.
yeah, I mean, one of the things that people have observed about the so-called work requirement is when there have been versions in the past of it, there are people who are working, but because of the administrative barriers, don't apply. So and
Right.
some cynics would say that was actually part of the plan to reduce the roles because of that. And again, that's just nonsensical. So that's the concern certainly that I have. I think a positive thing, although how it plays out, I think is going to be an issue, is a, a a focus that disability rights, first of all, does not exist in isolation. And in particular, we must recognize the intersectionality of disability rights. So
Hmm.
these experiences of cisgender white males and African American women, lesbians or otherwise, are not always the same, right? And so our civil rights laws don't tend to take that into account. They do tend to compartmentalize. But the disability justice movement in particular, which has a number of elements, including very much a focus on disability people with disabilities themselves being in the forefront of advocacy, and we could talk about that for a minute, but also about recognizing that, again, disability is not an isolated identity. Its identity cuts across other kinds of identities, and we have to be aware of the fact that for any particular policy, it may land differently depending on the nature of the person that we're dealing with.
I think that's absolutely, I agree 100% with that. And the other move in the disability justice space, as distinct from disability rights, is a focus away from rights and away from law as this sole or dispositive remedy for disability discrimination, and just a clear recognition that one by one individual rights are not going to solve the kind of deep-seated structural deficits that exist and the kind of subordination that pre-existed any of these statutes themselves. And so, that kind of recognition of the limits of the law and the limits of a rights-based framework. Not to say, again, that rights are not important. I don't understand disability justice to be saying that. Instead, I understand it to be saying that there is, in fact, a need for an intersectional model and set of principles for how we think about the harm that's at issue, right? So the frame of the harm itself and the remedy itself too. So you can't think about it along one axis. You have to think about it along multiple axes.
Yeah, I mean, as a old civil rights lawyer, I always feel nervous about giving up on. You're right; it's not they're not saying to give up on a rights-based model, but I think also one has to recognize on its own statutory rights, constitutional rights are will not be enough. That we have to have other kinds of developments, and I think we'd be remiss if we didn't say that an important part of the story we've been telling here, which is, maybe because we're lawyers and talking about lawyers is focused on cases and statutes, is the political movement that has existed with
Absolutely.
regard to
Hmm.
many of the things. So, as I'm sure many people know, if you've seen the movie Crip Camp, the regulations under Section 504 were long delayed until people with disabilities said basically had enough, and among other things, conducted a 30-day sit-in in the San Francisco regional office of the Health, Education, and Welfare Department. It's a huge point in the movement in terms of getting activity. The ADA itself was the product in part of the Capitol crawl, where people crawled up the steps of the Capitol to demonstrate the need uh, for this statute. The group ADAPT, which has been a powerful group to, among other things, push back against efforts to repeal the Obamacare back in the first Trump administration and other things. So these things go hand in hand, and the development of self-advocacy and peer support and other groups, I think, again, has told us that, the motto of the disability rights movement, nothing about us without us, is to say not only do we want to be included, but we have to be leaders of that movement. And again, the role for non-disabled people, I think, is one of allyship with those folks, to say, okay, there are times, when I shouldn't be a one who's front and center because I'm not the one who has, is in this category and somebody else should. But then there are other times where, maybe one can be helpful. And so humility towards one's role in that movement, I think, is important, particularly on the part of non-disabled people who may be supporters of others.
I think that's right. And I think we've also seen the nothing about us without us permeate legal organizations for people with disabilities as well. So DREDF, Disability Rights California, other protection and advocacy organizations, the ARC, these organizations that are leading legal advocacy organizations are also ones that are reevaluating and thinking about the role of people with disabilities within their ranks as lawyers. And I think that's a key part of it too. I think it's also another another trend that we're seeing now, and I hope we will continue to see in the future, which is really incredibly positive and powerful, is not only disability rights organizations and legal organizations coming together, the DREDFs, the ARC, the NDRN, all of these organizations, but working across civil rights organizations. And so many of the major voting rights cases are also cases now where it's not just, the NAACP, but it's NAACP, DREDF, plus the ARC. And so you're having disability is seen as a piece of the civil rights puzzle, very much in the way of thinking as we do about disability justice, that it cuts across. And so when we talk about voting rights, we can't talk about it in the context of race without also talking about it in the context of disability. And I think that that's an incredibly powerful development, one that's exciting, and one that I hope to continue to see in the future.
Yeah, and you certainly see it, for example, in some of the criminal legal system and police citizen interactions where race and disability may be involved in a black deaf motorist, for example, stopped by a police officer. How much of it is his race? How much of it is his deafness, which may lead to a, sometimes tragic kind of confrontation. And I always look for these, when these incidents are reported, to think, okay, are they reporting about the disability? And because sometimes they don't, or sometimes, or and again, media, others who are observers may, in a sense, kind of trivialize that piece, but it's really kind of all together. And again, we have some unfortunate examples where you can't really separate out how much a role disability is playing and how much a role of race or gender or other kinds of conditions. I think maybe next to last type of thing, also just to mention, is another important principle in the disability rights world and people with disabilities is that of universal design. That we should think society includes people with disabilities, a huge percentage of our population. And it's a lot easier to think in advance of how a particular structure or set of policies would apply to people with disabilities when you're creating them than it is later to have to kind of backfill and accommodate. And of course, a key element of 504 and the ADA, an important one, is that of reasonable modification or accommodation. We wouldn't want to give that up, but the fact of the matter is, if you're building new housing at this point or developing it, if you make the doorways wide enough to accommodate somebody in a wheelchair, you don't have to spend money later in order to widen a doorway when that might have been more difficult. That's one example. There are many others, but increasingly, I think it becomes important to just say, in the community of people we operate, local, state, national, international, people with disabilities are part of that. They're no longer, again, with some important exceptions, segregated in institutions out of sight, out of mind. They're part of us. And if they're part of us, then we have an obligation as a society, both at the governmental and non-governmental level, to embrace them, to include them, and not to make a kind of need to make a sort of special adjustments. So, one of the things I rail about is even providing educational services to this group, the special education. When we call things special,
Hmm.
it tends to, even if it's meant in a positive way, easily kind of carries over into thinking, well, why as a taxpayer should I spend for that? Or why should I do that? As opposed to, we should care about how our society is structured to include as many, to be as fully inclusive as it can be.
I agree. And there's, when we look at the issue of disability, we have to remember that at least, and I think this is an underreported number, I think it's a low number, but 56 million adults have one or more disabilities in the United States, right? That number is reported by the CDC. And that number can be seen in all of the different spaces we discussed. The Atlantic Monthly just put out an article yesterday called Accommodation Nation that talks about the prevalence of people with disabilities, students with disabilities on college campuses and in elite universities, and talks about how this is creating a major problem in terms of the way that universities function and trying to work through what that actually means. And there's sort of multiple ways to look at it. Some people might look at it and say, actually, this means that's what the ADA is doing. This is the ADA generation doing its job and providing services for students with disabilities. And another view is students with disabilities have always been on campuses, and whether they disclosed or not, or had the accommodations or not, and succeeded in spite of, as opposed to with supports, that's another question. So I think the framing, and this is definitely an issue for not only the present but the future. The framing is going to matter here. The framing as to whether this is a quote unquote problem or whether it is a marker of success somewhere in between. I think the important issue is not so much how we see it, but how we respond to it, although that's affected by how we see it, whether it's a problem or not. This invokes the question of universal design and universal redesign. It's probably prompting us to think more universally about the way in which we provide, as educators, the education and services that we do. So,
Yeah.
I think this is one of those moments, just like with the interpretation of disability, and we have to kind of use this as a moment for discussion and dialogue. And it's powerful if folks are willing to come to the table and talk.
Yeah, exactly. And I think as our population ages, I feel this very personally, there are more and more people with disabilities or who will either who will develop disabilities. We like to say that disability is a club you may be asked to join at any time. And in some sense, you hope to be able to join it because the alternative is you're not around for it.
Hmm.
And that means that again, your self-concept of how you operate in the world may change because of again conditions that develop. And it's important to see that as not, oh, my life is over because I don't have the same mobility I have anymore, but rather, I have to make certain adjustments in order to continue to do what I want to do. And so the more that we can, I mean, disability is part of life, the more that people can embrace that and understand it not as, some kind of negative comment about them or some slide into full dependency. I think the better kind of society we will have, and the more we will feel comfortable being in that.
And the
Well,
more that we have an accessible world where a person finds themselves needing an accommodation or needing something, and they can, say, well, I can go outside. I don't need to specifically ask for an accommodation. The world is constructed in a way that, I have ramps and curb cuts, and I don't have to ask for access, a special access that makes it the quality of life much better, and the feeling of belonging and inclusion at its strongest.
and as you know, the curb cuts example is a great one that many of us have used because now it's quite common in almost every jurisdiction for there to be curb cuts
Hmm.
put in because I think of the need for people who have mobility impairments, using wheelchairs and otherwise, to be able to be out in the world on our sidewalks. But we also know that those curb cuts can be used by anybody. And so a parent with a young child in a stroller, someone who's, jogging on the streets who wants to go in a straight, all that, they can go up and down these
Skateboarders.
curb cuts. Right, right. Skateboarders, exactly. Like, I won't even go there. And so when you have that, I don't think people would look at that and say, oh, there it goes again. That's sort of those damn people with disability. It's like, wow, this is cool. And maybe that wouldn't have happened without the need to actually make that as an accommodation. So, I think, and we could go on about things like what about, handicap parking spaces and how do people feel about that? And, I guess what I want to say, maybe leading into our conclusion is as an area of law and as an area of society. I was once asked, well, like, why did you get into this area? And, or, like, almost like, what's wrong with you? And my response, like with all these kinds of things we've been talking about, like why wouldn't you want? I mean, it's intellectually challenging. It's critically important. It overlaps with issues of poverty and race and everything else. It's rich for anybody, I think, to look at. And that's then leads to my commercial for folks who are interested in these issues. Our Disability Rights Committee of the section meets monthly on usually on the fourth Thursday of every month. Last month was Thanksgiving. We're postponed it till tomorrow. And we do a lot of activity. We talk about a lot of these issues in the committee. We have done webinars on legal developments. Last year, we did one on Supreme Court cases in the disability area because the court was pretty active in that. We have proposed resolutions before the ABA House of Delegates, including ones having to do or co-sponsoring ones having to do with pushing back against the effort of jurisdictions to make it easier to involuntarily commit people with mental health disabilities, which is happening in a number of states, and which I think is very unfortunate. In addition, one of the things the committee did recently was several of us worked together and put out a special issue. I will hold it up. Um, Disability Rights, the work continues. We had a number of wonderful articles by people with disabilities, other advocates. It's the third special symposium issue the section has put out since 2000. It was wonderful, as I was one of the co-editors, wonderful to work on that. So there's a lot of work to be done, I guess I want to say. And so I hope those of you who have been watching this have found this discussion helpful, and also maybe it'll pique some of your interests to get involved with us. I'll just conclude by saying that, first of all, I want to thank Jasmine for her wonderful participation. I knew in suggesting that she be my accompany me on this, that we wouldn't have to, spend a whole lot of time. What are you going to say? What am I going to say? Because just kind of the kind of conversations we've had. So appreciate that.
Thanks,
And to
Bob.
everybody who's watching us, I want to thank you for being part of this important dialogue. The issues we explore today are complex and they're challenging, but by coming together in areas like this, we think meaningful steps towards progress can be made. And the work doesn't stop here. It continues with the actions that our committees and other elements of this section can take. And again, we encourage you to be involved. So please if you're interested in these issues and related ones, again, the section on civil rights and social justice, celebrating its 60th anniversary is certainly the place where you want to be. So thanks again for your participation.